Okay, great. We're back for our fifth and final segment here on what does GDPR really mean for human resources data. So beyond our introduction, we had a segment on notice, consent, and legitimacy. We had a segment on information technology performance standards. We had a segment on governance and accountability. We had a segment on data breach and notification. And now we are to the final and in some ways maybe the biggest strategic point, which is the cross-border transfer solution. So the good news under GDPR is that the cross-border transfer solutions that were available under the directive are going to continue to be available under GDPR rules. The bad news is pretty much everything is under assault when it comes to cross-border transfer from a judicial review perspective at the moment. So at a high level, the big picture options are Privacy Shield, which is a replacement for Safe Harbor, model contracts, this thing called binding corporate rules, and then kind of an other bucket, which is actually the other bucket is maybe not quite so useful necessarily in the employment context because it deals with things like consent and necessary to perform a contract, et cetera, things that make some sense in the online world where there's choices and cross-border provision of services, but maybe not as relevant necessarily in the human resources context. But let's talk briefly about the first three. So you may or may not know that I was on the core team negotiating the Safe Harbor privacy arrangement with Europe when I was with the U.S. Department of Commerce in the 1990s. I will just say that Safe Harbor was struck down by Europe's highest court a little over a year ago, most unfairly, in my view. They were very strict about striking down Safe Harbor, largely on grounds related to concerns about U.S. government surveillance. And so in the wake of Safe Harbor being struck down by Europe's highest court, thankfully the European Commission and the U.S. Department of Commerce were already talking about a replacement vehicle. Safe Harbor was a good 15 years old at that point, so was in need of an upgrade, much like GDPR is an upgrade from the directive anyway. And they managed to close out those negotiations in a way that I think were really calculated to address a lot of the concerns raised by Europe's highest court. So we have a Privacy Shield option, which is for U.S. organizations, an ability to do the due diligence to confirm compliance with Privacy Shield rules and then make a filing with the U.S. Department of Commerce that the company complies with Privacy Shield. And if you don't comply, you're going to be subject to enforcement by the Federal Trade Commission as well as several other layers of arbitration and independent dispute resolution. So that's one option. You can call it a certification option. Another option is called model contracts, and that would be contracts between privacy contracts, standard privacy contracts between a European entity sending data and the U.S. entity or non-U.S., because contracts work anywhere outside of Europe, receiving the data. And essentially, the contracts are intended to limit how the recipient uses and handles the data, to subject the recipient to local jurisdiction for data protection authorities and courts, et cetera. A challenge for us in the current environment is not only did we have Safe Harbor be struck down and replaced by Privacy Shield, some concerns about ongoing challenges to Privacy Shield, the model contracts themselves are now under assault from a judicial review perspective. And so if you are an organization that is moving a substantial amount of human resources data, one thing you may consider is whether you go belts and suspenders at this stage. There's some pros and cons to doing that. The pros would be if model contracts get struck, you have Privacy Shield there to support, or vice versa, so you've got a little bit more protection from a compliance perspective. The cons are the rules are a little bit different between the two. I wouldn't say they conflict. We've had some people be worried that they could not do both compliance with model contracts and Privacy Shield. I don't believe that's the case. I believe that they're additive to each other, so they don't necessarily directly conflict. But you'd have to look at it. For example, if you have data flow that's coming from Europe to the U.S. and you find that you have done an internal investigation and you might now need to disclose data, either employee data to either the Securities and Exchange Commission or the Department of Justice, for example, in connection with a compliance issue. Privacy Shield has, I would say, more flexible rules to disclose were mandated by U.S. law, whereas the model contracts essentially imply that you might impose model contract terms on the U.S. government agency to whom you would disclose the data, which we all know won't happen in practice because they won't let you do that. So in any event, so there's a little bit more flexibility for Privacy Shield with those types of disclosures. Conversely, model contracts are certainly better for any data flow that goes from Europe, not to the US, but Europe to Asia, or Europe or Latin America, et cetera. So there's some pros and cons, and you have to think about it. The final option is called binding corporate rules. So to give you a quick sense of the numbers, there's something north of 1,700 companies that signed up to Privacy Shield in the first 8 months or so of its existence. I am certain there are tens of thousands of companies that rely on model contracts. And there's somewhere just south of 100 companies that have achieved binding corporate rules. This is a good solution if you're a more mature privacy program and you have some time to and resources to implement into getting your own binding corporate rules approved by data protection authorities. There's no binding corporate rule form that you can go to. So it's a good option for a more mature program and something I think people are going to be looking into. So that's the quick summary. Now you know what you really need to know for doing GDPR compliance. And of course, always feel free to reach out. Happy to discuss any of these points with anybody. Thank you.